Okay, so I probably ought to talk a little bit more about this Pollock decision in 1896 that created, or as a result of that decision, the progressive Fabians, the progressive radical left in the era, sought for 20 years to get the 16th Amendment put in place to get rid of this 1896 Pollock decision, and this is why. In Pollock, the court was testing a tax an income tax that was applied to the rents earned by the corporations involved in the suit. And the court ruled that a tax on rent is actually a tax on property, since rent streams from property, it sources from property. And the court held that all taxes on property and persons were historically deemed, and were being deemed by this court, to be direct taxes. So in this 1896 case that taxed rent streaming from leases of property owned by corporations, they ruled that because the rent flows from property, because of the source taxed, it was a direct tax. And as a direct tax on property, because of the source taxed, it was necessary for the court to be able to sustain the tax for it to be apportioned to the states for payment, as all direct taxes are required by Article 1, Section 2, Clause 3 to be apportioned to the states for payment. They can't collect a direct tax from individual persons, neither corporations or individuals. So they ruled in 1896 that because of the source taxed, rent to a corporation couldn't be taxed because the source was property. Taxes on property are direct. Direct taxes have to be apportioned, and this tax wasn't apportioned. So because of the source tax, the tax was deemed to be direct, and because of the lack of apportionment in the tax legislation, it was deemed to be unsustainable and unconstitutional. So they struck it down. Now here's the problem. The whole point of the Fabians going after the power to tax income was ultimately to enslave the people and tax their labors and the fruits of labor derived from the exercise of the right to work, treat them as though they were taxable income to the federal government, and thus enslave the labor of the American people. But if a tax on rent streaming from property is unconstitutionally direct because of the source tax, well, then wouldn't that same argument, and since all taxes on property and persons are deemed to be direct, then wouldn't that same argument apply to streams of revenue deriving from the individual person's exercise of their right to work? So you can't tax rent streaming from property, you can't tax revenue streaming from the labor of persons. Because of the source tax, the person, it would be a direct tax. So the Fabians went nuts because this decision in 1896 blocks them from implementing tax laws, income tax laws, to use income tax laws to go after tax on the wages of the American people conducted by right. Not any taxable privilege, not involving any foreign activity that would be taxable by the impost, and not involving any import-export of goods that would be taxable by duty. So this decision blocked them not only from taxing rents and other possible streams of revenue from the property, but also labor of the American people, labor streaming from the person. Both types of tax would have been held by that court to be unconstitutionally direct because of the source tax. So they worked for 20 years and finally got the 16th Amendment, which says Congress shall have power to lay and collect taxes on income from whatever source derived, without apportionment and without regard to any census or enumeration. Now, the most important thing there is from any source derived. They're getting rid of the source problem constitutionally. So the court can't now go, because of the source tax, that's unconstitutionally direct. So what you have is the 16th Amendment prohibits the federal judges from using a source argument as the basis for a finding in the legislation before them that the tax law being tested in that legislation is unconstitutionally direct because of the source tax. So they got rid of the source argument. Now, without an enabling enforcement clause in the 16th Amendment, Congress isn't authorized to write any new law to enforce any alleged new taxing power allegedly created through the adoption of the amendment, because Congress has to have authority given to it at the constitutional level to write law to enforce a new power. All the other amendments have their own enabling enforcement clause to authorize Congress to write new law for the new powers intended to be created by those amendments, both before and after the 16th. So you can't argue that the 16th Amendment established a precedent where it was no longer necessary to have an enabling enforcement clause. This, of course, is why for 100 years the rumor that it's voluntary has persisted, because if they allege the tax is created by a power conferred under the 16th Amendment, it has to be voluntary, because there's no enabling enforcement clause to constitutionally authorize Congress to write law to enforce that new power. And in the federal courts, they have to show that Congress was constitutionally authorized to write the law to enforce the power alleged granted and exercised in operational practice, or subject matter jurisdiction in the court can't be established. That means the court can't help the government enforce the claim for tax that it's bringing to the court, asking the court to enforce against the citizen or the taxpayer. Without the enabling enforcement clause, you can't write law. That's why for 100 years, people have insisted it's voluntary. The minute you tell me that the alleged authority arises out of the 16th Amendment and its adoption, because there was no authority to tax labor before the 16th Amendment, didn't exist. So if they're taxing labor now, it has to be because of the 16th Amendment. But the problem is without the enabling enforcement clause, Congress can't write law to do that. The whole thing's a fraud. The judges have been lying to the American people for 75 years, since the end of World War II, when they started enforcing the tax on the wages of the American people as a result of getting away with the victory tax, which was actually the first piece of legislation that touched the wages of the American people with legal effect as a tax. The 1913 legislation didn't do it. Now, here's what they got wrong in 1896 in the Pollock decision. Rent doesn't stream from property. When was the last time you got a check from a piece of land? Rent streams from the tenant's use of the property. And in this case, there was a farmer leasing the land from the corporation and growing crops on it. So what you have here is rent streaming from the lease on the consumption of a commodity, because when you plant crops on the land, you use it up and you make it worthless if you don't reinvest green fertilizer, plowing it back into the ground. So when you grow crops on the land, you're consuming commodity. Land is a commodity. And that makes the tax on rent to the corporation an indirect tax in the form of an excise on the use of the commodity, the land, and it makes the excise perfectly legitimate to impose, because the corporation is enjoying the privilege of incorporation and earning every penny it earns, and therefore every penny that comes to it is taxable. So it's not the source that prevents it, because it wasn't the property, it was the tenant making the lease payments. That was the true source, not the property, but the tenant. So that's what happened in 1896. It ruled it was unconstitutionally direct because of the source tax. It passed the 16th Amendment to get rid of the source argument. Without an enabling enforcement clause, that amendment has no legal effect on the American people. It can't, because Congress isn't authorized to write any new law. The only persons the amendment controls are the members of the federal courts, the judges of the federal courts. They're no longer allowed to use a source argument as the basis of a finding that the tax being tested is unconstitutionally direct because of the source taxed and the lack of apportionment in the direct tax. So that's what happened. And that's why I think they got it wrong. And getting it wrong has led us to where we are today. All they had to do was say in 1896 it's legitimate excise, and they never would have passed the amendment. The amendment came out of this decision and their desire to get over the source argument, which they perceived would prohibit them from taxing earnings streaming from the person, the same way that it was ruled to be prohibited to tax the rent streaming to a corporation. So that's what's going on. That's what the amendment really does, and that's what the amendment doesn't do as well.